This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome Dr. Stephan Athan to the show. Now, Dr. Athan is the president of Athan Engineering, a full-service engineering consulting firm. He's a sought-after expert witness in engineering with work ranging from failure modalities to compliance and beyond. Dr. Athan, thank you so much for joining me here today at the Roundtable.
Thank you, Noah. I'm thrilled to be here, and I appreciate the opportunity to be a part of this.
Absolutely. Let's jump right into it. You've been an engineer for over 30 years, including over 10 as an adjunct professor. How did you first get started in expert witnessing?
I think I was thinking about this. I think it had to be around the early 90s. I graduated in 80 with my first degree, and then I was working on my master's and Ph.D. beginning in 89. My wife was an attorney, and she was a very well respected and well-known attorney in Tampa, and we got to talking one day about it, and she asked me if I knew any experts on a particular case, and one thing led to another, and then she said, "Why don't you think about doing this?" And that was really how I got into it. In fact, one of my professors at the university, Dr. Burdick, he was a very well-known expert in his field, and in fact, I read his book. He had a book on, becoming an expert witness. And one thing led to another, and I realized that I could put my expertise to work, and it was really fun doing that.
So for those of our listeners who aren't fortunate enough to be married to an attorney, what are some of the, some of that first advice that she gave you to, how do you be an expert witness? What does that entail? What were the kinds of questions that you had, and what were some of the, how did she explain the job to you?
I was so fortunate to have been married, and I say to have been. My wife passed away 2 years ago, but the most thrilling thing about this, Noah, was that unbeknownst to me, my wife became my first mentor in this realm, and I strongly advise any expert to be working with a mentor or someone in this field. But the most exciting thing was when we first started interacting, and for decades we worked together. I was, in fact, worked pro bono for a case with her firm, which was a thrilling case. It was a criminal case, to be exact. But the one thing that I guess I picked up on, I want to caution engineers on, is in engineering, as you know, our world is black and white. It's black and white. It's scientific, it's proof, it's theory, it's empirical analysis, it's repeatable experimentation. In the world of litigation and law, it's purely gray. So we're talking about plugging in a black and white behavioral mindset into a otherwise gray world. And that took some time to get used to. I worked on a number of different cases. I worked on criminal cases. I worked on civil cases, patent infringement cases. What I can tell you is an expert on an accident reconstruction or medical device failure is totally different from a patent infringement case. And one thing I can say I was very proud of, and I still am, is that my goal was to find the smoking gun. And my wife would say that, if we could just figure this one thing out, we can add this to our client list. And I work on both sides, plaintiff and defendant. But I would credit my wife with really getting me involved and getting excited about it, and really continuously helping me through the process.
So besides working with her firm, what were some of those first phone calls like? You get somebody calls you and say, "I need an expert for X, Y, and Z." How is that vetting process?
That's good. That's a good question. That's a great question, because the one thing I learned, I think, early on was to be yourself. I'm obviously a fairly high energy guy. I'm a passionate engineer, consummate scientist, and geek nerd at the end of the day. And it's kind of hard when you're meeting people for the first time. You're not really sure how to present yourself. You're interested, but you want to be respectful and professional. And at the end of the day, I learned that to be yourself, and when you talk about what you know. Don't try to outsmart the attorneys. You will never do that. Just be yourself and try to follow through with your commitments. For example, I would tell attorneys I often find the smoking gun, and then of course nothing better would turn out. An outcome would be for me to find the smoking gun, and they were bedazzled. Even a criminal case I was on with my wife's firm, she never imagined ever that anybody could come up with what I came up with to address her client. They were a client for the defendant. It was the state of Florida versus her defendant. And I think that's the biggest thing is be yourself, be confident. You've got to be fearless and have thick skin. And I think you've heard this term before. I've heard it from attorneys that experts are basically, at least patent infringement experts, are considered hired guns. And I want to make a distinction between patent infringement experts and other experts. They're two totally different types of people, of processes. An expert, for example, on a accident reconstruction case, they just tell me what happened. That's all they want to know. And in my wife's case, in the criminal case, it was extraordinary. We actually gleaned information from a state trooper's dash cam that no one was expecting or prepared to see. And I found it, and that was a smoking gun. So in the patent infringement world, however, it's far more complex, far too many variables, and you've got to really kind of settle in. It takes time, over a period of time, to get settled in with working with the attorneys and to understand what they're really after.
Do you ever work on a team with other experts in the same action?
Absolutely. In fact, it's often many experts involved, and we meet and collaborate with these experts. But there are rules. There are rules of the game, which I'll say. I made a note here. Be sure to tell you that the most important thing is to understand the game you're about to get into, and to speak the language. But in answer to your question, absolutely, there are other experts. I think at the end of the day, my advice is to hold your own. You are a paid expert. Act like it. Go in there, do your job, and stick to your guns. And of course, you got to be careful when you're delivering testimony and you're delivering reports and things like that. You've got to make sure you understand what's going on. Preparation is the most important thing. I have a very unique method. I think I don't know anyone else doing what I'm doing. For example, I get a call. All I have to hear is a smidgen of the case. They don't even have to tell me about the whole thing. Just give me a smidgen. I will find the case. I will often find the complaint. I will find who the plaintiff is, who the defendant is, who the lawyers are, everything about the case, because I have access to that information on databases on the internet. So the bottom line here is working with other experts is a standard part of the process.
When you're writing your report, are you typically given any kind of boilerplate to get started, or are you writing them whole cloth? And in either case, how do you interact with the other experts in forming that report? Are you just, taking your part and running with it, and then it gets all combined in the end, or do you actually collaborate in writing?
I think the most important thing there is the one thing I guess I could answer it this way from an engineering perspective. This is about collecting dots. Now, collecting and connecting dots. First of all, most experts collaborate with the attorneys on any report. In fact, I think it's essential. And the reason for that is twofold. One is not just because the expert has something to offer, but because there are things going on that the expert might not be privy to. And that has to be demonstrated and articulated in a report. Just something as simple as I'll give an example. I was deposed recently, and I was responding in the deposition of my report, and the opposing attorney asked me, Dr. Athan, do you ever use Wikipedia for your research? And without thinking, and that's the first thing I learned, is to stop before you answer, take a breath, think about what you're going to say, formulate it, and then say it. And there's a reason for that, including the fact that the attorney might want to jump in. But this one I was so sure of, I jumped in and said, absolutely not. And he said, well, would you please turn to page 23? Where did that picture come from? And by golly, he got me. It was a picture that I got off the internet of a particular incident. And so you got to be real careful, because remember, the lawyer's job, and these are the smartest people with whom I've ever had the pleasure of working. Their job is to win. And our job, I came up with a term. We're like supporting actors in a movie. We're the supporting actor. We're there to do a job. There's certain expectations, but at the end of the day, these attorneys, or who are the smartest people that I've ever had the pleasure of working with, they really run it. And so even things like reports, you've got to work with them. You've got to kind of integrate with what they want to get the point across. And this all starts, by the way, at the complaint. I've read complaints from firms that I don't agree with, and I'll tell them up front, I don't agree with that complaint. I don't agree with the outcome, and I don't think I can help you. And that's something very important, because I believe if you don't really believe deep down inside what's going on in defending or representing from as an expert, I think I can be more effective by being passionate and really connected to the case. But as far as reports are concerned, rebuttals and things like that, it's essential that we work with the attorneys. And this goes with small firms and large firms. I worked with Jones Day 2 years ago, the most thrilling experience of my life. These are the smartest people I've ever had the pleasure of working with out of the DC office. It was an International Trade Commission case, by the way, and it was extraordinary.
Do you find, you said that you worked on both the plaintiff and defendant side. Do you find that there's any significant difference between the two?
No, I really don't. I think it's just a matter, the complaint tells you everything. It really describes the story. I'm on a case now on the plaintiff side, and to me, the case is black and white. And the case with Jones Day was that we were on the defendant side. And interestingly enough, that was black and white to me. So it's just all about your perspective. I think having been in the industry as long as I have, I'm very comfortable with my experience and my background, and I like challenging and being challenged on any level with respect to the area of expertise that I possess. And I think that applies to whether it's plaintiff or defendant. I don't personally think there's a difference. I think it's exciting work, and the whole process. It's like a movie, like making a movie. At the end, you start and you finish, you produce it, and you go back and look and sit in the audience and watch what you did, and you want to feel good about it.
Besides plaintiff and defendant, there's a couple other permutations, especially with reports, which we were just discussing, including initial reports versus rebuttal reports, for instance. Do you take any different strategy when dealing with the two types of reports?
I don't personally. I really follow the lead of the attorneys and learn what their strategy is, because it's all strategic. It's very strategic. And I think the hard thing for me one day was to realize that I don't have all the answers. That's what I'm used to doing in my world. But I don't have all the answers. I wish I did, but I have access to neither all the information or all the reports or all the resources. So at the end of the day, you've got to kind of bound what your role is and just move forward in that respect. And this applies, I think, to both small firms and large firms. The reports, the rebuttals, I like working with and collaborating. I don't think I would ever dare write a report myself without it being reviewed. And if you're going to accept it to be reviewed, then you've got to be prepared to have it criticized and edited and so forth. So if we're going to do that, I think we just should start off at the beginning and enter this process together.
Backing up to those initial phone calls, what part of the vetting process is on your side? In other words, what are the sorts of questions that you ask and you decide whether or not you're going to take an engagement? You mentioned that you want to be invested in it. You want to feel like you're on the correct side and you can feel good about arguing. Do you have to turn down a significant number of cases for that reason or for any reason?
I think the one thing that helps me a lot is knowing as much as I can. As an engineer in my work on government contracts, which is what I work mostly on, classified government contracts, I had a mission. My mission was knowing more about the customer's problem than the customer knew. Now I tried to apply that in this world of expert witness, and something happened right off the bat. I'll give you an example. It sounds trivial, but this has played a big impact in my interactions in the first phone calls. I learned, and I was complimented by a lot of expert, seasoned attorneys of what I do. What I do is when I get a call, what I decided to do was answer their questions, the attorneys' questions who were interviewing me over the phone, as though I'm being deposed. Now, that can be tricky because the only attorneys that get that are the seasoned attorneys. I've had a few novice attorneys who have called me and interviewed me. And the problem with that is they get offended because I'm not answering their questions. They don't know I'm answering the questions as though I were in a deposition, which the seasoned attorneys get immediately. And so I had to make a decision. Who do I want to satisfy here? I'd rather work with the seasoned attorneys, answer the questions like I'm being deposed, and then let them decide how good a fit I am. Because if I'm going to be interviewed by a novice attorney, and they're gonna interview me and hire me because I'm answering the questions the way he wants me to answer them, I don't know how effective I can be on the case. And oftentimes I know as much or more about the case, at least from the complaint, than they do. So I've got to make a decision. And my decision, I want to give them the best version of me that I can. And I think the way to do that is to take that approach. Now, I've been criticized. That isn't the best approach, but that's my approach. And I get down to the nitty gritty. And I've actually been hired in the middle of an interview. The attorney will stop me. Go, stop. I've heard enough. You're hired. And I take that approach of answering. And I've had these attorneys compliment that approach of my answering as though I were in a deposition. They want to hear that. They pick right up on that. These are smart guys. They don't have time to mess around. They're there. They're very, very, very busy, and they don't have time. They may be interviewing a dozen witnesses. So your time is important with them, and I think the best way to do that, in my opinion, is to take that approach.
So you recommend that other experts give that a shot?
It's a personal decision. I have made up my mind that I'm not going to. I'm going to respond on my terms, and I want to be. I think I'm being transparent. Also, I want them to know everything about me. I'm not hiding anything. I'm telling the truth. This is who I am. Even my energy level, I've been complimented on. I love your energy. We want you in front of a jury. This is what this is all about. And I love being in front of a jury. I love telling stories. I love using analogies. And so, decide who you are. Decide what your brand is. What are you selling? And then stick to it. You may not be hired by everybody, but you'll fit in beautifully with those that do hire you.
We talked about this a little bit before the show. You've had a long career. You've written a lot of things, and you have a fairly extensive online biography. How does that come into play when you're getting hired? And then what are some of the caveats with people going back through things that you may have said or done a long time ago? And how do you deal with that in court?
That's a very, very good question, and more important than most people might think. Let me start by saying that if an attorney can attack your credibility, they will. Now, on that note, everything I write that's in the public domain is fair game, including my professional profile that I've placed online. I want these attorneys, I want everybody to know who I am. They say that you shouldn't put more than 10 years of your professional experience online. I want to put it all there. I was born a geek nerd. And as positive as that may sound, having been born a geek nerd, my dad was an MIT graduate, and I've been doing nothing but engineering my entire life, and that's very clearly displayed on my profile. Despite all that and the goodness that I think it transcends, attorneys will find something to use against me. So they're going to do that anyway. There's no such thing as a perfect expert. I don't care who you are. The opposing attorney's job is to attack your credibility, and they will use whatever means, with all due respect, that they can, and as they should. My wife was a criminal defense attorney. She had some pretty bizarre cases, some very controversial cases. Did she believe in what they were doing? Absolutely not. Her job was to defend them, and defend them vehemently, and she did zealously. And this is when you get that in your head about this is their job. It's kind of an exciting process. It's like being on a deserted island with other experts, and each of you has a unique perspective of the universe. And so you're sharing these ideas. You've got to have thick skin. You got to be fearless. You can't be squeamish. This is a very tough business to be in my opinion, at least insofar as a patent infringement or intellectual property expert witness.
You mentioned earlier how important preparation is for you. Walk me through some of the preparation techniques that you use when you are, say, going into a deposition or you're going to be cross-examined. Do you use mock cross-examination? Do you use other tools?
I use everything I can get my hands on. As a researcher, fortunately, as a researcher early in my career, I learned that the exciting part of discovery is the journey. I know I'm going to find something. I believe I'm going to find something. I'm very confident and optimistic. I often say I can squeeze water from a rock. I love that excitement of when you find something, especially when you find, I've literally found a smoking gun against big players, big corporations that were shocked and couldn't figure out, how did I get that information? I think the most important thing is to be prepared. You can never be too prepared, in my opinion. You can never be too prepared. I think you can be a little underprepared, but starting with the content, having access to the complaint, having access to everything that you know about the case. Now, the good news is I've been in this business a long time. Now, on one side, I can say I have a big advantage because I know what we did over the past 40 years. That can be a detriment to me. That can be something that the attorney can attack me on. And so you've got to kind of take, it's a give and take thing. But at the end of the day, preparation is everything. The attorneys, I think, really admire someone who's really prepared. I've had attorneys who ask me, how did you get a copy of the complaint? We didn't send it to you. And it obviously wasn't proprietary or confidential. And if it is, I wouldn't have it. I mean, you don't want to play that game. But sometimes I went online and there it is, right? Popped up on Google search, the very thing that I thought was proprietary or confidential. Of course, once it's in the public domain, it's available to anyone. But I think at the end of the day, preparation is everything. Preparation helps in multiple ways, Noah. One is it helps you immediately. It helps you for the near, mid, and long term. Whatever you learn now, you're going to apply later. And if you intend to do this for a long period of time, and this is exciting. I've been in this business for 44 years, and to be doing this at my age, at this part of my career, it's the most exciting thing I can tell you I do. It's one of my top 5 priorities. My children and grandchildren are first, my expert witness work. I'm a pilot, I'm a musician, and I'm a researcher. And those are the 5 priorities right now. And this is the most exciting. And I stick to my guns and I don't deviate. I stay within my boundary, my bound of who I am and what my area of expertise is.
How do you tell me a little bit about, how you are an expert and how you remain an expert? What does kind of the category of expertise mean to you?
I think at the end of the day, I think that's a personal decision. I know in my career, I have a bachelor's, a master's, and a Ph.D. in electrical engineering. I'm highly focused in the area of expertise. I had a thrilling career. I was plugged into Silicon Valley. I would make monthly trips out to Silicon Valley, and I'm talking about the area of integrated circuits, of working in this field back in the day before anything like this became available. Back in the 70s, we were using the most archaic, antiquated techniques you could imagine. You couldn't imagine that we're doing today. We can fit billions of transistors on a piece of silicon the size of your fingernail. Now, that didn't just happen overnight. That happened over a period of many years. In the old days, in fact, I would say collectively, there's 5 major steps to integrated circuit design. And I've worked in all of them. Most folks coming up like I did from the old school worked through all these different areas. But once you get plugged in and once you kind of understand what's going on, then the changes aren't that significant. And that allows you to stay up to speed on everything. I know what my strengths are. I know what my weaknesses are. And I'm very, very honest and transparent about those. At the end of the day, when you're connected to conferences and symposia and workshops like I've been over the decades, and you're working with some of the smartest people I've ever had the pleasure of working with in academia and industry, I briefed Congressman Bill Young, who was the chairman of the House Appropriations Committee many, many years ago in D.C. in his office, on how to make microchips. That I think was the most thrilling moment of my life, because I felt I was only intimidated because of who it was, not because of what I was delivering in terms of content. But I think at the end of the day, if you feel really comfortable and confident, you know who the players are. It's like any business. If you're in the business of movie making, you know who all the directors and all the actors are. Well, in engineering, it's the same exact thing. We know who the players were. A lot of it's changed. It used to be HP, then it became Freescale, then it became other companies and NXP. But at the end of the day, they're doing the same thing. Obviously, it's higher tech, but not much has changed in the context of a seamless integration and flow of technology. That's the beautiful thing, is the technology. We feel pretty confident that we know what's going on. Do I know every player in the field today? No. Do I know? I heard today that NVIDIA is now the top highest rated company in the world, in the country, at least anyway. I know what NVIDIA is doing. I know what they've been doing from day one. In fact, I've met Chris Malachowski at the University of Florida, one of the co-founders. So it's about being plugged in and really understanding, and I think having a passion. Now, I will say one other thing happened a few years ago. There was an opposing expert. And by the way, I always research the other experts. I want to know everything. I want to know everything I can know. And it turned out that this fellow didn't even he had a technology degree from a reputable school up in Chicago, but not any advanced degrees. And I thought to myself, how can this guy be doing this? And then I saw him on the stand, and he was very effective on the stand. And that's what it boils down to. So I like the fact that you don't have to have a Ph.D. or a master's degree or a MD or anything. It helps, certainly. Why does it help? In fact, let me make this comment now. At the end of the day, it's all about the jury. What is it the jury's going to see and hear? And so the credibility issue, it encompasses a broad range of issues. In that particular case, he was great on the stand. He connected really well with the jury. And so, going back to your question, I think it's just a personal thing. Are you comfortable up there? Are you effective? And I remember one deposition I was on a few years ago. I walked out of the deposition room. It was in front of an administrative law judge. We were doing a remote teleconference, and I was focused. I was so focused on this conference, and it was a beautiful interaction between me and the plaintiff and defense attorneys. And then when I walked out, I was in my zone. I was like almost zoned out in another world, like a runner's high. And I walked out of the room, and there's all the attorneys waiting for me, and they clapped, and they all came up and hugged me, and I'm like, whoa, I guess I did a good job. So it doesn't hurt to have confirmation like that, but at the end of the day, you kind of conclude that maybe I was doing the right thing, and I'm going to stick to it. But it's so exciting, and like I said, I know I have some trials coming up this year. They're going to be exciting. I've already been through depositions. They were awesome. I learned something new then. I didn't know you could go 7 hours in a deposition, but you can. And I think that's a legal limit of how long a deposition can last. I've never been in a 7-hour deposition, but there you go. But it's really exciting, and I encourage anyone, if you're going to get into it, you've got to make a commitment, in my opinion. I've met some amazing people, really, both from a technical standpoint and legal, lawyers and experts. And it really is a very respectful, professional field we're in. I love being a part of it.
You work in a couple different venues. You do ITC and you do federal district and probably others. What are some of the differences, or are there differences overall in the way that you prepare, or the way that the actions go, or you bill, or anything else?
Absolutely. The one thing I can tell you, the ITC, of course, there's no jury. All you do, you testify in front of an administrative law judge, and that's it. The entire process takes literally from beginning to end months. Now, most patent infringement cases take years. It might be a year before you even deposed, and then another year before the trial. I mean, these are multiple years. ITC is a completely different animal. And I have to admit, the folks that I was thrilled to be working with, I have a tireless work ethic. I love working. I work all hours of the day and night. I push myself to just unbelievable limits. But I got to tell you, these folks that I work with, if I can divulge the firm, it was Jones Day. I can even give you names. These guys were amazing. They really gave me a run for my money. I've never worked harder in my career that I did with these guys. And I'm telling you, I didn't think other people worked that hard. But we were going at it, and it was an ITC case. It was a very important case. The outcome was extraordinary, and I found that, and they would tell me this ITC cases are very different. The procedural issues are the same, a lot of the same kinds of things. The biggest thing is there's no jury. You're in front of an ALJ, and that's what your goal is. That's your target. And otherwise, preparation's the same, reports are the same, depositions are the same. And yeah, it's just an exciting process, to get in and be with others that are in that same mindset that you're in.
What are some of the things that make that relationship so good? You seem to really enjoy working with Jones Day, for instance. What makes that the relationship between the attorney and the expert just really, really hum along?
I think the best thing is working with other people. Now you're talking about attorneys. These are literally some of the smartest people with whom I've ever had the pleasure of working. Now, with that intellect, with that intelligence, you have to understand comes a little bit of arrogance and ego, and this is hard, if you're not prepared for this. Now, I was married to a woman, an attorney that had that same sort of outlook. You have to be that way. I think the fun part about it is the same from the Matrix when he said the way to understand someone is to fight them. Well, this is what I felt like I was doing, was getting in the gym on the mat with these Jones Day lawyers. We get out there and we do it. We get in a fist fight, not literally, but we really get down to gouge and punching. At the end of the day, we're on the same team, and they need that. They complimented me for pushing back and not just settling in for every little thing they were telling me. In fact, the folks that I work with, they were amazing. They were so humble. They actually would admit, "Gosh, I didn't know that. I just learned something," and that's so exciting because they have a job and they're respectful and professional, and they're expected to behave in that manner. So I think the big thing is just being able to work with these folks and putting your ego aside, but holding your own and not backing down. At least tell them what your argument is and how you're justifying the argument. And oftentimes they'll agree with you. So and that was what it was like. I mean, otherwise, it's no holds barred in these processes. And that, by the way, was the best preparation for the depositions that there could be, because that other attorney's going to come after you, and they want to cut your throat. And you've got to be calm, and there's methods of being calm. I use techniques that I've learned over the years, things I've learned and to do and not to do, very important things, and they've all been very helpful, and I'm still learning. So I do it now. Is again, the exciting part is to think to myself, what am I going to learn now? I learned some amazing things back in December. I was up on depositions up in New York for a firm, and that was awesome. We did 2 depositions in 1 week, and both of them lasted 7 hours each, and that alone was new. But it was kind of like going into battle. I love reading military history. My passion is the Pacific Theater during World War II, Chester Nimitz, and that mindset. I watch Midway every week just to get excited and inspired by the way they thought about it. And it's really about playing a complex game of chess. These attorneys are doing what they do. It's what they do. And I think if you look at it, pragmatically, from a high level, it becomes very exciting. It's a very exciting process. This is our beautiful legal system. And one more comment on that issue. I just learned in New York that we're the only country in the world that handles our litigation the way we do insofar as patent infringement cases, with discovery and juries. There's no juries outside of this country. I didn't know that until recently. So we have a really unique process. I don't know, and wouldn't claim that it's more or less efficient, but it's a very unique process. And to be a part of that, for me, from an existential standpoint, is very exciting.
Absolutely. One of the things that you've brought up a couple times is the feedback that you've received. How important is it to receive feedback after an engagement? And in what form does that usually take? Do you ever have, for instance, the attorney doing jury polls or anything like that? Or is it usually more informal?
It's often informal, Noah. And one thing, that's a great question, because I learned something a long time ago. The first thing I do, I preclude every discussion with attorneys with this comment. I said, look, guys, we're on the same team. You're not going to hurt my feelings. You need to tell me very honestly, give me some feedback, tell me what I did right and what I did wrong. And when you break the ice like that, because they're very professional, they treat you professionally as Dr. Athan and Dr. Athan. And I like that, and I get it. But at the end of the day, we have a job to do. and I don't have time. They don't have time to screw around, and so I get some very brutal feedback. I've been cautioned on a few things. Most of it is very positive. I'd say 98% of it is very positive. Oh, that's a great little thing you do there. I like that. Keep doing that. And what you said, what did you mean by this? Is it manufacturing or is it fabrication? No, it's manufacturing. Fabrication is a subset of, oh, I get it. So, you just got to kind of interact with them, because you know what, deep down inside, they're open to learning. They really are humble, very humble, but they've got a job to do. And that job requires them to be egotistic and back at you and pushing hard. That's their job. I wouldn't hire an attorney that didn't have those attributes. My wife's been on cases where she's deposed law enforcement officers, and after the court, I've been in court, I haven't seen this. They walk up to her and she tears them apart on the stand. But they'll come up to her and they'll say, "Miss Athan, that was awesome. I want you to know that I was just doing my job." And she looks right back at them and she says, "Well, I was just doing my job." So it's about really doing our job. If you're afraid or you're intimidated or you're fearful of doing your job, you need to find something else to do, because that's what this world is all about. And I say this world, I mean the patent infringement expert witness world.
Before we wrap up, do you have any cases that you can talk about? Obviously, you can't, divulge specifics, but that kind of change the way that you approach expert witnessing, or were kind of seminal moments in your expert witness career, either good or bad?
I do. I have so many. I'll try to pick one out. And I'll preface this by saying that these other cases, the criminal cases, the accident reconstruction, the medical prosthetic failure cases, those were very, very different from patent infringement. Those were about finding the smoking gun. I don't think there's such thing as finding a smoking gun in a patent infringement case. They're way too complex. I've got a 10-page glossary here of terms that I review frequently that every patent attorney knows and every expert should know. These have to do with patents and claim construction and these kinds of terms. But in answer to your question, I think probably one of the most memorable cases I was on was with my wife's law firm. It was a pro bono case I worked because we wanted to avoid any conflict of interest of my being part of the defendant. And it was a state case in circuit court. Her client was stopped speeding. It was up in Sumter County. And long story short, my wife came to me one day and she says, "I have a case. And something's bothering me about this case. There's something, I don't know what it is, but can you help me?" I said, "What do you need me to do?" She goes, "Well, he was arrested after being stopped for speeding. And I don't believe they had probable cause to stop him. So we have to find a way to throw the probable cause out, because if we could throw the probable cause out for stopping him, the whole case goes away." Well, here's what happened. He gets pulled over for allegedly speeding. And this is really important. It was a state trooper. State trooper is asking him questions. He's leaning in the passenger window asking the driver questions. And the state trooper says, "Have you been smoking?" And the driver, without thinking, said, "Yes, I was smoking this morning at my house." Well, unfortunately, or fortunately, depending upon how you look at it, in the state of Florida, if a law enforcement officer smells marijuana, that gives them probable cause to search a vehicle. So the state trooper says, "You've just given me probable cause to search your vehicle. I'm going to cuff you, put you in my car, and search your vehicle." They arrested him for possession. Long story short, my wife came to me, and after giving me the facts, I'm thinking, "Gosh, what do you want me to do?" She said, I think he says he was behind a truck." Now, I'm an expert on radar, and I know how radar works. It's Doppler radar. It's black and white. And you can't detect a vehicle's speed if it's behind a larger target, in this case, a big truck. Anyway, so I put together a hypothesis of what I thought happened. I had nothing to really go on except my data. And I put together what I thought was a really effective, formidable defense. And they deposed me. The state attorney deposed me. I went in. I gave him my information. And my wife was a little bit, she says, this is the best you can do? And I'm like, "Yeah. I think it's a pretty good case." She goes, "All right." Then all of a sudden, out of nowhere, my wife calls me one day and she says, "We got the dash cam." Now, without elaborating, because I want to make this short, let me just tell you what happened. I found the smoking gun. Literally found the smoking gun. There, and you could. This is all in the public domain. All this entire case is my testimony. In fact, it's the only time in my wife's career where they deposed an expert twice. They deposed me twice, pre-dash cam and post-dash cam. And when they found out what I discovered in the dash cam, which was the smoking gun, that really was, it set the whole case apart. And I'll tell you what it was. It was a very neat nerd engineering solution. So we had to find how fast the vehicle was traveling when the trooper first saw him. Now, there's statutes I won't go into that place certain requirements on the state trooper and the law enforcement officer that they must do in order to validate what they were doing. Anyway, we're looking at the dash cam, and I needed to know I needed speed. I drove up to Sumter County. I was in the middle of the street with a tape measure. I stopped traffic. I'm measuring distances. I'm measuring yellow lines. I was out there during the season, the same day a year before. Where were the shadows? Where was the sun? And I'm looking at all this data, and I need speed. I've got distance, but I need speed or time. If I have time, I can derive speed, because speed is displacement over time. And I'm looking. This was late one night. It was so exciting. I'm sitting up late at night watching the video, the dash cam over and over, and playing it over, rewinding, over and rewinding. And then I slowed it down. And as you slow a video down, as you know, it kind of shows in what looks like frames. Tick, 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 and then the light bulb went on. But wait a minute. What's the frame rate of this camera? Well, the frame rate of that camera was 30 frames per second. There was my time. And guess what? He wasn't speeding. And
wow.
I won't tell you what happened later. What happened later was even cooler. But I'll leave it to your imagination to imagine what could have happened that was better. It was awesome what happened after that. That was a two-part process. But that was the fun part, was to find the smoking gun. And that's pure science. You can't refute that. Even the judge, and I don't get compliments too often from judges, but that judge complimented me on my finding. In fact, on the way out of the courtroom, two attorneys ran up to me and gave me their cards and said, "Call me. We want to talk to you." So you did a pretty good job. And it was all science. It was engineering. It was stuff that you are expected to do. That's your job. Do it. There's no more rewarding outcome, I think, than that.
What an incredible story. In my mind, this was going to go to the frequency of like a flash bulb for like a blinker or something like that.
Yes.
I thought that might be
my wife, and God rest her soul, she was so blown away. She goes, "Oh my God, I can't, I never thought of that." She goes, I never wasn't, we were married almost 40 years. And she said, I just didn't think of it in that level. I really appreciate how engineers think. They look at the world differently than the rest of the population. And that's really what it was about. I mean, it was one of these many serendipitous moments that we have, through the course of history. I was literally late at night, my eyes were folding, and I kept playing the video back and forward and back and forward. And I just happened to slow it down enough to where it was, the images were, the frames were like popping up on the screen. And then I'm thinking, that's when the light bulb went on. And I get excited just thinking about it. But there were others like that. There were others that good many years earlier. But again, in the world of patent infringement, there is no such thing as a smoking gun, because it's a collection of information. It's claims, and the claims cover, the claims cover a broad range of issues, including prior art. Prior art's a huge thing. What did someone do 10 years before this? Was it the exact same thing? And you've got all kinds of issues: validity, invalidity. You've got all kinds of terms, and that's the beauty of the process. So if you understand the process, you understand the language. The more you understand the process and the language, I think the more effective you can be.
I do have one follow-up question before we wrap. In these technical engineering types of actions, if there is a jury, how do you effectively communicate this to a layperson in a way that they understand? Do you use graphics, or do you just talk about it in simpler terms?
Great question. That's probably the most important process. That's probably the single most important part of the process is the jury. And this is one thing I feel very gifted, is the ability to describe complex issues in layperson's terms. And even working with attorneys, I like using analogies. This is things people can connect with analogies. And that's really what I think by the same token, as effective as I believe I've been, and as complimentary as I've been given by other attorneys, even opposing attorneys have come up to me and complimented me on my delivery. I've seen experts get up there and just crash and burn because they really don't know how to connect with a jury. If you think about who these people are and how to you're connecting with them, even the way you look, it's all about we're human beings. It's the human experience. You cannot ignore that. And the attorneys know this. They know this better than anybody. And I think that's probably the single most important variable. Now that you've mentioned it, is at the end of the day, ask any attorney. If any attorney ever tells you, yes, I'm not worried about the jury, I pretty much know what they're going to come back. They're lying to you. No one ever knows what a jury is bound to come back with. And that's a beautiful part of our system, of our process, is the jury-based process. I love it. I just think this is such a neat thing. My wife used to refer to going back to the framers of our Constitution and the democracy and the written words and things. And ultimately, it's all about. I've seen witnesses crash and burn. I've seen defendants crash and burn in courtrooms. So I learned something, I guess, was common sense if you think about it. It's all about your delivery, your presentation, your delivery, how you act, how you behave. And remember, I'll add one more little caveat to that. That's the main focus of the opposing attorney, is to attack your credibility. What does that mean? It means making you look bad in front of a jury. That you're there to make them believe in you, and their job is to show that they can't believe in you and to support their case.
Do you have any last advice for experts, and in particular newer experts, before we wrap up?
I would just encourage experts not to be an island amongst yourself. Work with other folks. Don't be afraid. Look, don't be afraid to reach out and ask questions. The worst thing that can happen is say no. But learn as much as you can. And you know what? I have to tell you, I've worked with Professor Emeriti. I've worked with professors. I work with folks in academia, and you got an interesting mix. At the end of the day, I think the most effective experts, regardless of their credentials, knew how to play the game. They understand what our role is. And I got to tell you, I was eyes wide open on one case a few years ago. I was listening to their expert. He was a professor emeritus out of North Carolina, and I'm thinking to myself, this guy's just, what is he doing? And then it dawned on me what he's doing. He's doing exactly what he's being paid to do. And what he ended up doing was, and this is an important piece of advice. If you're going to write a report and then you're going to be deposed, the deposition is often about what's in the report. That's all you have to stick to, is the report. If they ask you a question that's outside the scope of the report, it's not, you don't answer it, or you refer back to the report. So, that's how the game is played. Most of us like the fact, I think the biggest criticism with engineers that I've read and I've watched videos is we don't know when to shut up. Stop talking, just answer the question. And by the same token, I remember years ago, one of my friends or someone said, just don't answer the question. That's the worst thing you can do. You don't answer the question. There's a way to answer the question. And the attorneys, they know this. They're so skilled and so seasoned in this that being connected into that kind of gives you that understanding of what they're looking for. But at the end of the day, it really encompasses a broad range of behavior and academics and intellectual experience. I would not recommend anyone going outside of their area of expertise. I mean, that's the whole point of a subject matter expert. What are you an expert in? And sticking to your guns and tell them I don't have any experience in that. And you know what? The hardest thing for me was to say I don't know. As simple as that may sound, as trivial as that may sound, it took a long time for me to stand, sit in a deposition and say I don't know. I just don't remember, because you want to give them an answer. This is what you're trained as an engineer to do, is to provide solutions to complex problems. But sometimes you just don't remember, or you don't know. And so you should be true to yourself. After a deposition, we were talking earlier, they send you an errata. Are there things in the deposition that you didn't come out right, or that were changed, or that were transposed incorrectly? That's very important, because at the end of the day, despite the fact that the jury will never see the deposition, that's what those opposing attorneys, that's their script. That's the main script that they're going to be using to attack your credibility.
Sage advice. Dr. Athan, thank you so much for joining me here today.
My pleasure, Noah. Truly a pleasure. And I hope I didn't go over too much, but I would love to do this anytime. And good luck to all those experts out there.
Absolutely. And thank you to our listeners for joining me for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.